I'm going to begin by giving an introduction to two men who need no introduction. In fact, for the first time ever, I'm introducing two speakers, both of whom have their own page on Wikipedia. Quite impressive. To my left, quite fittingly, is Michael Ratner. Mike is the president of the Center for Constitutional Rights. He's also an adjunct professor at our mutual alma mater, Columbia Law School. Mike is a civil liberties lawyer par excellence. He's a driving force behind the center, which has been perhaps the most active legal organization fighting the administration over its detention policies and the so-called war on terror. Little known fact about Michael Ratner. His brother owns the New Jersey Nets. How cool is that?
That's really cool.
Sounds capitalist to me.
To my right is Stuart Taylor, Jr. Stuart is a columnist for the National Journal and a contributing editor at Newsweek. He's a brilliant editorialist and writer. He's always scrupulous about the facts. On a personal note, Stuart can be absolutely maddening. There are times when you want to disagree with Stuart, but he lays out his case in such a compelling way that in the end you have to agree, despite your predilections. Stuart is also a lawyer with a degree from Harvard Law School. He practiced briefly at Wilmer, Cutler, and Pickering. He's a former reporter for the New York Times, where he was for a time, the Supreme Court reporter, and also he was a reporter for the American Lawyer. The little-known fact about Stuart is he is only 13 or 14 articles shy of having 1,000 articles published in the New York Times.
Oh, my God. No. What? Really? That's fantastic.
It is amazing.
I don't think I'm going to get there.
So close. So here's how we're going to proceed. Each speaker will have 5 minutes or so to lay out his case. Because Michael argues in favor of prosecution of quite a number of high-level Bush administration officials, Mike will go first. Stuart will then explain why Michael is wrong and why President Bush ought to pardon, quote, any official from cabinet secretary on down who might plausibly face prosecution for interrogation methods approved by administration lawyers, including, I think, as Stuart will explain, those lawyers themselves. We'll then let them go after one another for a while. If there's a lull, I have a few questions that I will pose, but I do want to leave a fair amount of time for audience members to ask questions. So without further ado, let's proceed. Michael, the floor is yours.
Well, thank you, David, for being here, and Stuart, thank you. Stuart and I used to work together a little bit. It recovered me, at least during the Central America days, I think, in the 80s. But I'm pleased to be here. Coming down on the train, I actually had an incredibly moving experience. I got an email that said a few blocks from here, Judge Leon had actually granted writs of habeas corpus to 5 Bosnian Muslims, the ones who are at Guantanamo and had been accused of initially of bombing of an attempt to bomb the embassy in Sarajevo. As soon as they got the writ, as soon as they got the right to go to court, the U.S. withdrew the charges. And I was so moved, really, because 7 years ago is when we at the Center first brought the cases for the Guantanamo people, along with a couple of other counsel. And I tell the story, really, partly because it demonstrates to me what you can do even if you're starting from a case where people think you're never going to get that, it's not politically doable, there's no law in your favor, you can't get it. And it also, I start from the premise that you can't believe anything the government tells you. Really anything. They up until the day of that hearing, they had said, we have the evidence to bring these guys in as the people who plotted to bomb the Sarajevo embassy. I also tell it because for me it's a crucial, really, taking down of one of the building blocks of what this administration has done over the last 7 years, and that's the incommunicado offshore detention policy that they have at Guantanamo, that they have at secret sites, and they have around the world. And we're here really to discuss a second building block, and I think the taking down of that building block, and that's what I call the torture program, the war crimes program, the idea that you can take a human being in custody, abuse them, coerce them, commit war crimes on them, inhumane treatment, and torture them. And I think we're taking that down because I listen, and even though I've been disappointed in other presidents in the past, I do listen and I do believe Obama when he says, he will make sure we don't torture. He has said it repeatedly. He has said it on his website. He has just said it again recently in a 60 Minutes interview. And I think that's crucial. And I think there's a lot he can do to make sure that this particular administration doesn't torture. He can issue executive orders applying the Army Field Manual to not just the military, but to the CIA, to other agencies, to anyone who's in custody of any U.S. agency. He can withdraw all of these orders, all of the OLC memos, all of the material by which this administration has implemented its torture program, and he can declassify and make public a lot of the documents we haven't seen. And I think this is going to take us a long way towards stopping what I call the torture program. At the same time, as Obama has said this, you see it leaked out of the government, or leaked out of the transition team a little bit, and you never know from the transition team what's really coming out. But this one says that there's little or no chance, or little or any chance, that justice will go after those who authorize torture or abusive interrogation. So you see that on one hand, little or any chance, and then you see Eric Holder, who may be our new Attorney General, really making a very strong statement a few weeks ago or a few months ago against the torture program and saying we owe the American people a reckoning. Whether he means prosecution or something else, we don't know. So you do have an issue, a situation that's in flux right now, that's fluid, in which I think we can actually make a difference in pushing in a certain way and not simply saying it's never going to happen, don't push it. The decision is not set in stone about whether they are going to begin a criminal investigation, which is the first step, I think, that they should be doing. To not do that, I think, would be the wrong decision. And here's why. I think if Obama really wants to make sure we don't torture, he has to launch a criminal investigation. We can all name the key players. They're part of what are called the Principals Committee, part of what is called the War Council. There's lawyers, and there's some of the principals. The key ones are Cheney, Tenet, Rumsfeld, others. The key lawyers are Addington, Yu, and Gonzalez are the three key lawyers. But there's others along the way. And that's the way to end torture now and in the future. And the reason I say that is that's what will send a message that we don't torture anymore, nor will we torture in the future. That's the way to set up a deterrent so that the next president doesn't simply say, well, in the name of national security or whatever else, I can just redo what Obama just put in place. I can go torture again. And when you think about it, you think about, some people say, well, we need new laws, new executive orders, but think about whether it's possible to what I call Addington U proof any law you pass against torture. I think you can't do it. I think good OLC people, good in quotes, can twist, Office of Legal Counsel people can twist any law they want to get a justification for abusive conduct. That's one reason why you have to have a deterrent of investigation and prosecution. The second reason is what you have here is this just wasn't misinterpretations of law, twisting law. This was actually an assault, a war on law itself. What happened here is the president said, we are above the law. In the name of national security, we can do whatever we want to human beings. And so that all the laws you pass this year or next year are completely irrelevant to a president that's going to say, we are above the law. And therefore, you absolutely need the deterrence. You're going to hear a lot of reasons why we can't do prosecution. Just remember that to not do an investigation and prosecution is to give impunity. And think about the message that impunity sends, not just to this government, to every precinct in this country, to every other country in the world. That you could torture in the, quote, name of national security, so can we. We don't want to send a message of impunity. You're going to also hear, well, they have legal defenses. And we can talk specifically as we get into what their legal defenses are. Because let me say, from the very first, these guys had one thing on their mind. They wanted to abuse people, coerce them, torture them, but they were very worried about the two statutes that we have on our books here, the anti-torture statute and the war crime statute. And they had to figure out a way to get around them. And that's where they already started this program even before they had their ways around them, but that's where you get this flurry of memos to try and figure out what they call a golden shield, what I would call really fool's gold. I don't think it works. I think the defenses will do them no good. But it's not really a question for Stuart or I to decide here. It's a question when they go before a jury, for a jury to decide, were these people acting in good faith or bad faith? Was it reasonable? Were these defenses reasonable? But one thing I can promise you, if there is no investigation and prosecution here, and if there are pardons, I can promise you that, as I've already tried to do in Germany and France, there will be cases in Europe brought against what I call the torture conspirators, and they will be pursued everywhere they go. Because one way that Europe will definitely pursue them is if they know they're pardoned in this country. Another thing you'll hear is that this will divide the country. It's the wrong time to do it. You know, in my view, it's not a reason for leaving in place a precedent that says the president, when he wants to, can engage in torture. Already, the fact that there is a division of some sort on this in the country means that the next time this comes up, we will again get a torture regime. Our job really is to close that divide in the country, and Obama can do a lot to do it. You know, when I heard the speech that he gave on race, it was like one of the most incredible speeches I've ever heard in probably the last 20 years. He could give that kind of speech on abuse and torture and say, so that we never do this again, I'm going to stop criminal investigations. One thing you'll also hear is, well, Michael, it's unreal. We have a listserv where we debate these issues. They say, you'll never get it. You know, you'll certainly never get it unless you demand it. That I can guarantee you. And I can also remember, you know, it took 35 years to get Pinochet. You know, memory is long on this kind of stuff. And it's only taken us 7 years to get the first people, not out yet, but a judge, federal judge, ordering them out. So I'm not pessimistic about this. And really, the worst thing I think I hear on this is that, Michael, we don't want this in the administration, maybe some people said it to me, we don't want you looking backward. Why should we look backward? Why don't we look forward and ban torture from the future? Well, if you get my point here, when you go after people, when you criminally investigate them, you're not looking backward. You're looking forward. You're making sure that in the future we're not going to have torture. It's not about looking backward. It's called deterrence, and we don't have a problem generally in this country with the idea that criminal law is to deter other people from engaging in criminal law. That's the argument. I'm going to just close with a quote by General Taguba. General Taguba was one of the investigators who was, by the Bush administration, to look into the Iraq Abu Ghraib scandal. And what he said was, after he left the administration, after his Taguba report, he said, "The commander-in-chief and those under him authorized the systemic regime of torture. There is no longer any doubt as to whether the current administration has committed war crimes. The only question that remains to be answered is whether those who ordered the use of torture will be held to account." And that is the only question that remains to be answered. And that's really up to all of us. Thank you.
Stuart?
Thank you. I agree with a great deal of Michael's eloquent presentation, except for the most important part for our purposes today, which is his view that high government officials should be prosecuted, investigated first, of course. My answer is they should not be, based on what we know, and my prediction is that they will not be, which I had hoped would sound like a bold prediction in this room until Senator Leahy made the same prediction quite confidently in the paper today, Senator Leahy not being one of the more conservative members of the Senate. I think that, contrary to Michael's view, just to respond quickly, prosecutions are not the only way to prevent these kind of abuses from happening again. I think the best way is to adopt new, more enlightened policies and laws. Indeed, the torture program has stopped, as far as I know. I'm not aware of any reports of anything that could be called torture by anyone in the United States government in several years. I'm not sure when it stopped, and maybe Michael knows something I don't know, but I think it stopped. Public opinion, public exposure did that. As for impunity, well, the people who are being called war criminals by Michael and others I think, do not feel that they acted with impunity. I'm not sure you need to put them in prison to provide a deterrent for people to do improper things. But let me get to and I'll touch on pardons later if we get to questions. But first, I'm going to give 4 basic reasons why I think we shouldn't have prosecutions. First, as Michael forecast, I do think that such prosecutions would tear the country apart, would blow up President-elect Obama's hopes of lifting us out of our multiple crises. But I don't ask you to take my word for it. Listen to what Barack Obama said in an interview in April. I'm quoting, "We need to distinguish between really dumb policies and policies that rise to the level of criminal activity." He went on to say, "I would not want my first term consumed by what was perceived on the part of Republicans as a partisan witch hunt, because I think we've got too many problems to solve." Well, I think, obviously, I don't think he was saying if we've got a cold case that somebody committed illegal torture, we should ignore it. But I think we should, I think he was saying if we're making debatable cases, it's going to be counterproductive. Second, while I deplore the brutal interrogation methods that were approved at high levels, and while some detainees were certainly tortured in the usual meaning of that word, there's no evidence that high-level officials acted with criminal intent to violate the drafted anti-torture law or the War Crimes Act. In this regard, I'm reminded of a line attributed to Talleyrand, I think. It was worse than a crime. It was a blunder. The main reason that I think there was no criminal intent is that, as Michael also forecast, they were relying in good faith on the advice of legal counsel, especially the Justice Department's Office of Legal Counsel. Now, this isn't the same thing as a corporation hiring a fancy New York law firm and paying them $9,000 an hour to give them a carte blanche to do what they want. This is the institution that prosecutes crimes, federal crimes in this country, the only institution that prosecutes federal crimes. It would be illegal, I think, and unconscionable for the same Justice Department that authoritatively advised people that waterboarding and the like, for example, within careful limits, did not violate the criminal law, to turn around, same Justice Department, say, come to think of it, it did violate the criminal law now that the administration's changed, so we're going to prosecute you. Now, reliance on advice of counsel is no defense if the client's acting in bad faith, but I think that's not. I'd be glad to revisit that in the Q&A. But briefly, all of the methods approved at high levels in this matter have been approved not only by the gonzo executive imperialist John Yoo, whose famous 2002 August memo I was one of the earlier denouncers of as indefensible. Indeed, under that memo, you could take 500 Guantanamo detainees down to the beach and behead them one by one. Saying we're going to keep doing this until you start talking. That is not what was done, and a lot of lawyers in the executive branch, more respectable and more mainstream than John Yoo, after his memo was withdrawn, approved all of the techniques that were approved at high levels as a matter of policy, including waterboarding. Now, maybe they were wrong about that, but they were not. These were serious lawyers, and the executive branch officials who relied on them were entitled to rely on them. And I can elaborate later on why waterboarding, which sure does seem like torture in the lay sense, could be deemed not necessarily a violation of the very narrowly drafted torture statute. So that's law. But third, even if a technical case could be made for prosecuting high officials, it would be unwise and unwarranted as a matter of prosecutorial discretion, both for the reasons noted above and because these officials, hate them or not, were honorably motivated. They were not doing this out of sadism. They were not doing it to terrorize the population or maintain themselves in power. They were doing it desperately afraid. And by the way, House Speaker Nancy Pelosi, among others, signed off on these techniques without protesting them. They were all doing it because they were desperately afraid, for good reason, that unless they could extract the secrets of al-Qaeda terrorists such as Khalid Sheikh Mohammed, many more American lives would be lost, and they would be to blame because they shrank from doing what they were advised they could legally do. Indeed, they feared that this building and the rest of downtown Washington and/or New York would be obliterated by nuclear devices or depopulated by biological warfare if they didn't get the secrets. The danger of that happening eventually remains very high, although we maybe become a little bit numb to it. Fourth, the approach that Michael advocates, in my opinion, would have the wrong kind of deterrence. Yes, it might deter people from torturing, but it also would deter them from doing some tough things that need to be done. And it would make it hard to get good people into the toughest jobs. It would be hard for President Obama to get good people into the toughest jobs. I wonder, for example, whether he'll have trouble finding a first-rate person to be the Assistant Attorney General for the Office of Legal Counsel. Here's what a woman who would be an outstanding Obama appointment said to me, in essence. As a reasonable person, I would approve the legality of actions that the human rights groups are going to call criminal, even though they aren't. There are life and death decisions that have to be made instantaneously. Who would want to have to spend years defending herself from charges of being a war criminal? Now, Michael mentions that they better be careful about vacationing in Europe. Well, he's right. They better be careful because they could well be prosecuted there. And the last point I might make before stopping is a little bit of a hypothetical question. Suppose that your child were kidnapped and held for ransom by two evil men. Suppose they threatened to kill your child unless ransom was paid by 5 p.m. Suppose further that you took the ransom to a 3 p.m. rendezvous with one of the men. The police were following you. They grabbed him. For 2 hours, they try every they can try: sweet talk, harsh talk, good cop, bad cop. They invite you to stay there, and you make a plea, a passionate plea. Please, my child, kill my child at 5 p.m. if you don't tell us where she is. The man is silent. The man is laughing. Now it's 5 p.m. I forget, the deadline's 6 p.m. 1 hour from when your hidden child is to be murdered. The police captain starts beating and kicking the suspect while saying, "I'm going to beat you to death if you don't talk." Would you tell the captain to stop? Think about it.
I trust you'd like a moment to respond.
Sure. I think we can go point by point and just do a couple of the points, Stuart. Yeah. I mean, I think this question of what Obama thinks in tearing the country apart and what the Democrats think is, while it's out there and of some importance, that if I guided my actions by that, I wouldn't be litigating any cases. I mean, my goal is to change that attitude and to make it one in which they understand that what has happened here is we have gone off the fundamental principle, really, of a democracy and of law, which is that there's a fundamental right to be free from torture, and that laws, and that we're a government of laws and not of men where people make the laws. And if they don't understand at this point that that's as important, or maybe more important, or maybe it's worth taking some risk with the population to say we have to stand for these principles and begin an investigation of people who violated those, then I hope in the next couple of years to make them understand that. That's the first point. The second one on the memos, I just think the memos are garbage, and I don't think they're going to be any defense. And I think that every time it gets raised as this golden shield, it's completely absurd. I mean, one is a lot of the conduct happened before the memos. There were people in secret CIA sites being abused, tortured, war crimes being committed, whatever, before August 1st, 2002, and being badly brutalized before the quote, "you" memo came out. So you have a problem because there's prior. Secondly, you have a problem in places like Iraq, which had the Fourth Geneva Convention applicable to it, maybe even still today, but certainly through Abu Ghraib and all of the incidents that happened in Iraq, when the so-called Rumsfeld techniques, the 15, 18 torture techniques, in the case 35 and then reduced that went to Iraq, were brought over there, and then they were under the Fourth Convention, and there's no memos at all about the Fourth Convention and the grave breach provision of the Fourth Convention. So there's those technical things. But the bigger thing is what happened here, and what if you read Philip Sands, if you read Jane Mayer, if you read really what happened with OLC here, they were not giving independent counsel as to what, they were not giving independent counsel. They were shaping their memos essentially around the policy. And even Jack Goldsmith says that in his book when he was at OLC, that they were shaping the memos to fit a policy that had already been determined. And they weren't really honest brokers in terms of the law. And they were in really, the best way to say it, they were in cahoots with these guys. They were in cahoots with Addington and Cheney and said, let's figure out, they went to them, let's figure out a way we can abuse people, let's figure out a way we can torture people, but really let's figure out a way to avoid the war crime statute, let's figure out a way to avoid the anti-torture statute, and give us memos so that we can use these as a shield so we can encourage lower level people to engage in them. Now it may be that lower level people have a defense with this, but certainly the guys who I consider really a conspiracy or aiders and abettors and who set this whole program up. This is not independent arm's length advice. And that came out as you look through the people who took that office after you left. Whether you look at, and particularly Bradbury, who came in last, and they put him on a temporary appointment for a month while they made sure. And then he wrote a memo that not just said waterboarding is okay, but that waterboarding, even combined with other techniques, is okay. So you have people who are completely under the thumb of the administration and not acting under the OLC. I don't think if that gets to a jury, I think the issue is it should get to a jury, but I don't think that a good faith defense is going to be upheld. And what you want here, what you want in a deterrence thing is, when you look at the war crime statute or you look at a Common Article 3 or the Geneva Conventions or the torture statute, the argument was that, well, it's not precisely defined. How do you tell what it is? And really what it is it's not precisely defined for a reason. Humane treatment is not precisely defined. It's defined in cases and by the ICRC, et cetera, but they don't want people going close to the line. And what you had here was an administration that twisted the law and not just went close to the line, but then way over the line.
Before Stuart has a response, you did not respond to Stewart's variant on the ticking time bomb.
Oh, because I consider it just ridiculous.
Well, explain.
I mean, to have to go. Yeah, of course, it's a powerful debating point. You hear it all the time, and there's a lot of different responses. But one is that the situation essentially never comes up, and is certainly not the one that came up as they took a person like whether it's Muhammad al-Qahtani or Abu Zubaydah, and a year after the fact, they engaged in torture of them. And what happens with, even if there is such a scenario that once in a zillion years will come up, what happens is every scenario then becomes that, and it becomes a slippery slope. That's one problem. You then think, this guy, well, what's wrong with torturing the guy who may know where the next attack is going to be if you're out in the field? That's one problem with it. Secondly, I consider the prohibition on torture completely absolute. So I don't buy into it. And the case that's closest to the one, Stuart, is, of course, a German case, where there was a kidnapped kid, and it happened a couple of years ago, and they took this German, and the German cop thought they had the right guy, and they basically threatened him with a gun and said, tell us where the kid is. And the kid happened to turn out dead. The guy never, I don't think he ever told him in the end, but he was dead in the end, and they prosecuted the cop, and the cop got convicted. So if you're going to take the chance that Stuart's saying, if that one case should ever come up, then you take the chance of a jury convicting you. And maybe you think the chance is worth it, but maybe it's not. So I just think that what's happened in this country is we've gotten this one scenario out there which doesn't come up, which is rare, unusual, and which somehow people just say, well, that happens, you have to open the door to torture. I don't buy it at all. It's just, it's contrary to really, it's contrary to law, it's contrary to even whether that situation ever comes up.
Would it follow then that if it did happen, and if it were your child, you would tell the police, stop, don't hurt this man?
Look, the reason people who are victims should not be the people who decide who gets the death penalty or who gets tortured is exactly that.
Are you going to answer that question?
Obviously our emotions. Emotions has even happened in these cases. I remember reading when we were reading about the secret sites, and the guys, Karaku, the guy who gave the waterboard, said people were waterboarded when he was one of the people supposedly who knew about it. He says their emotions, because after 9/11 ran ahead of him and they tortured people. That's what he said. So that's what happens in that kind of case. So you don't ask me. But I can tell you, if you talk to what happened here internally, and that's what gets me about when you go along here and you see what happened. They were opposed inside the administration at many turns. The FBI opposed them. They actually pulled themselves out of Guantanamo on these issues, pulled themselves out of, when their clients got taken away from them by the CIA, pulled themselves out and said, this is wrong, it doesn't work, our methods of rapport work, our methods in the Army Field Manual work, this is what works. That's not just me talking here as some progressive. That's internal agencies saying, that doesn't work. What the CIA did here doesn't work. We would have gotten much better information. And the information you get, the last answer on torture is the information you get is oftentimes false, because you say whatever your torturer wants to hear. And we know what we've been led down to with torture. We know about Abu Libby, the guy who they tortured to basically prove that Saddam Hussein brought weapons of was dealing with Al-Qaeda and had weapons of mass destruction. The guy is tortured. The CIA tortures him. Colin Powell accepts what happens, goes into the UN, and gives a speech based on this guy's evidence, and we go into the Iraq War. So I am not at all convinced that you begin torture.
All right. Can I respond?
Floor, yes.
I asked Michael, as some of you may have heard, whether he would tell the police to stop the torture if it were his child. I didn't hear him say yes. Now, maybe there was a yes buried in there somewhere, but I didn't hear it. Now, what he did say in various ways is, well, this never happens, this kind of ticking bomb hypothetical, which is false. It has happened. The hypothetical case I gave was a real case that's reported in the federal reports by federal appeals courts. It wasn't a child, it was a cab driver, but it was a beating, and it did lead to the discovery. The person led to discovery. The Israeli Supreme Court, same decision in 1999, I think it was, in which they semi-banned various coercive techniques, said, now, this works sometimes. They said, and they gave an elaborate report on a detailed case where a bomber who was en route to blow up a disco and kill gosh knows how many people was caught and stopped because they used, not torture perhaps, but harsh techniques to interrogate one of his colleagues. The German case, it happened. Now, it doesn't happen often. We have no quarrel on that. And I wouldn't think that we should be torturing people. I don't think we should be torturing people, period. We'll come to the question of what's torture. But it happens sometimes. And it's one example that dramatizes that sometimes the need to get information from people is desperate enough so that you might be tempted to try, if not torture, something more than rapport-building methods. By the way, Michael mentions juries a lot. Let's just put them in front of juries and let juries decide. I'd be surprised if he denied that juries often convict people of crimes that they didn't commit, because they do. The memos are garbage. Well, Michael, I don't think the memo written by, I think the memos written by John Yoo were garbage. I think they were entitled to rely on them, but I admit that's not an easy sell. I think Dan Levin, here's what happens. John Yoo's memo is written, and it's really signed by Jay Bybee, August 2002. Jack Goldsmith withdraws it, says I can't defend this, quite appropriately, in June of 2004. Goldsmith never says that any of the methods approved under the Yoo memo should not be approved. He just withdrew the Yoo memo, said I can't defend this legal analysis. The acting Attorney General, Dan Levin, then wrote a superseding memo that came out in February and was pretty well received among Democrats as well as Republicans when it came out. It had a footnote that said none of the methods that have been approved under this or under the previous memo they're all still legally okay if done within the. Waterboarding was the toughest thing that they had approved and the toughest thing for Levin to find legal. He had himself waterboarded in order to have a better understanding of what he's getting into before he said, well, this can be legal if carefully controlled, as in maybe 10 seconds, not 10 minutes. But, we don't know exactly what Levin's experience was, but here's how Christopher Hitchens, journalist who also had himself tortured, had himself waterboarded, described the experience. He said it's torture, by the way. This is torture. But I'm more interested in his detailed description. A man who has been waterboarded may well emerge from the experience a bit shaky, but he is in a mood to surrender the relevant information and is unmarked and undamaged, and indeed ready for another bout within a short time. But again, they did it again. When contrasted to actual torture, waterboarding is more like foreplay. No thumbscrew, no pincers, no electrodes, no rack, end quote. Now, I think I heard a scoff, but this is from a guy who was waterboarded and who said it's torture. But this is his description. This is what I went through. If you've been waterboarded and what you've been through, be my guest. Now, the torture statute is quite narrow. It's more narrow than the torture convention, the UN Torture Convention, because Congress, when they approved it, basically said it's torture if it's intentional, specific intent to inflict severe physical pain or suffering. That's one thing. And severe is a debatable term. I don't think what Hitchens described is necessarily severe physical suffering. It also says severe mental suffering, but it's subdefined and limited as the prolonged legal harm, those are the words in the statute, resulting from various various degrading forms of treatment and harsh treatment. Prolonged mental harm, I think it's fair to say, was intended to mean something more than having a horrible mental harm going on while it's happening, or maybe during the half hour after it happened. How prolonged it has to be, I'm not sure. But I don't have a problem with Dan Levin, having been through this and analyzing the statute as a respected and good lawyer, saying, well, no, it's not necessarily torture. I'll stop there.
Okay. On the memo, the footnote that we're speaking of was essentially, as I recall, and I have to go back and look at it, but in Jane Mayer's book they talk about it, about how that footnote got put in there, and it really got forced in there. It got forced in there. Levin was only a temporary OLC guy, and when he was leaving, they put that footnote in. Otherwise, you'd be talking about having techniques used, feeling that they were criminals from. And so he essentially was forced into putting the footnote in that said all prior procedures.
If you'd been Levin, okay, would you have gone along since your job depended on it?
What, are you kidding with that? No.
Do you know Levin?
No, I don't know Levin, but I'm telling you what I read in Mayer's book. So anyway,
yes, he was under pressure. The question is whether he's a man of integrity who yielded to some extent to the pressure because he thought he had a strong legal argument, or whether he's a whore.
I don't know the answer.
Everything I've heard of him suggests that he is not a whore.
I don't know, but I know that footnote came in there not exactly completely independently.
I grant that.
So, and the issue on waterboarding, look at tortures, since the... I have a friend of mine who was in Algeria. He was the editor of a newspaper. His name is Henri Alleg. And two things happened. One is he said, you never give up, or you give up, but you don't necessarily give up what your torturers want to hear. And the other description he gave of waterboarding, he described it as if death itself had taken over me. And that was his quote. And I think it's very different when someone is waterboarded in a condition for 10 seconds when they know they're going to be able to get up and get out and get their life saved, than when you're in a detention facility and you're waterboarded by people who have you stripped naked, who are using other procedures, cold on you, warm on you, all the hooding, the whole business, and then you're waterboarded in that condition and the feeling of death itself comes over you. I think I would define that as torture.
Quickly on that, we don't know exactly what the waterboarding rules were. They've never been made public. Levin's memo said, carefully limited. I assume that has something to do with time. It also has something to do with the difference between Spanish Inquisition waterboarding, which is described as follows. Captors force large amount of water into the lungs and stomachs of prisoners. That was not done in this program, from what we know. Dropping on their chests, that was not done.
We don't know any of that. What are you talking about? Well, we know that Bradbury put out a memo that said you can waterboard and use all these other things with it.
But we know that these guys... We don't know what the memo said the limits were. He has said there were limits.
I want to
Stopping on their chest, causing some
my
to cough
position
up
is no
water,
waterboarding is allowed. All waterboarding is torture. That's for start. Limits are not.
They didn't say that. Levin didn't say that.
No, he didn't say that.
And no lawyer since has said
that. That's none of those OLC guys said it. But there's no way. But the U.S. There was starting in the 1800s. When we accused soldiers of waterboarding Filipinos, we tried those soldiers for waterboarding. We tried people in state courts. It's a classic torture. You're not just going to draw little boxes around and say, if it's only for 30 seconds and if you don't stomp on the guy's chest, then it's not torture. Of course it is.
Well, a lot of pretty good lawyers disagreed with you, and the people in the executive branch relied on them. Now, to the extent that high-level officials approved, and I have no evidence that they did, waterboarding or other techniques that went beyond exactly what the lawyers said could be done, or to the extent that low-level people did, and there's some reason to think that some did, that's a different question. My argument is limited to reliance on what OLC said, pretty much.
I want to say a word about your definition of torture. I'm sure you've read Phil Sand's book when he goes through really one of the center's clients, Mohammed al-Qahtani, and what happened to him. 54 days of interrogation, directly really under the supervision of Rumsfeld and the Pentagon. And he was, 40, I forgot the number, but like 2 or 3 months of sleep deprivation, strapped into a chair, naked, hooded, intravenous liquids poured into him while he urinated on himself. And what Phil Sands did, the log of Mohammed al-Qahtani has actually come out, and it's a 54-page log of everything, not everything they did to him, because we don't know if there's some things that they left out. And they marked all the times in which he showed distress. He took it to a person who was a doctor to talk about whether this was prolonged, what happened to him, and whether there was mental damage during the period. And the first conclusion, of course, is a 48 or 54 day essentially abuse like that is considered prolonged. And the one thing you have to do in the definition of prolonged, it includes for mental pain or suffering procedures calculated to disrupt profoundly the senses of the personality. And that's what these procedures are all about. Stripping, hooding, dogs, the whole business. So they take out, after 54 days, just the moments in which Qahtani is indicating distress. And you read that chapter and you really want to cry for what happened here, because it's all that every day the guy is screaming and crying and just completely gone and just begging. It's 54 days of the most intense distress that you can read. And what this independent person concludes from an English hospital is, if this person were coming to me, I would have no issue but saying this person was tortured. There's no issue.
Quick response. I think a strong case can be made, and Sands makes a strong case, I've read his book, that the people who were dealing with Qahtani, the individual handlers, may have tortured him. You need to look at their criminal intent and so forth, and perhaps that should be investigated. It was investigated by an Army panel that you don't have to respect that said it wasn't torture. But we're talking about high-level people. Now, the interrogation of Qahtani was approved by, as a legal matter, by Jim Haynes, the Pentagon General Counsel, and by Rumsfeld. They approved a list of techniques. None of those techniques on their face look anything like torture to me, unless you do them every day for 60 days, which was done. In addition, a lower-level lawyer had sent up a memo to Haynes with the list of techniques, and waterboarding was on the list. By the way, waterboarding is something that is done to United States troops in training. Presumably wouldn't be done if they thought prolonged mental harm might reserve. Waterboarding, Haynes wrote a memo to Rumsfeld saying, well, we might legally be allowed to do waterboarding, but we shouldn't do it because it's against the traditions of the military. The CIA was doing it at that point. The Justice Department had said it's legal at that point. The lower Pentagon lawyer had said it's legal at that point. Haynes and Rumsfeld said, we're not going to do that. Now, then the interrogation was way out of control. I'm not aware of any evidence that it was closely monitored by Haynes or Rumsfeld, and knowing the every day of people in those surprised if they paid much attention to it until later on, as you know, people brought complaints to them.
You know what's interesting about, you think there's a lot on their plate, but in fact they were getting regular reports on all of these so-called high-level guys, and they were monitoring. And in this case, I don't think, I recall reading in a couple of places, I do think that Rumsfeld was on that case week to week and getting reports on what was going to happen. That's one thing about Mohammed al-Qahtani. But the other one, in terms of, I know I read your defense of Haynes on this, 15 techniques and not the 18 and his defense wasn't that his defense was that they may not be illegal, is what he said, and I won't give blanket approval at this moment. That doesn't mean, and I don't know the answer, whether on different cases he didn't give individual approval. What he was saying, I won't give a blanket approval to waterboarding.
Well, he never gave approval.
Let me finish, because the other 15 techniques that were authorized, when you look at them on a page, they're the dogs, the comfort items, the stripping, the hooding, the sexual humiliation, the religious stuff, all of that, which taken individually, they do amount to cruel and inhuman and degrading treatment. Most likely not torture, with the exception for me of certain things like an unmuzzled dog at a naked person. I consider that torture.
That's not in the memo.
Let me just finish this. Yeah. So you have the 15, and when even Goldsmith looked at these, he said, look, when they look at them, the 15, they look a little antiseptic. But what happens is they're not used, and there were no limits in the Haynes memo or the Rumsfeld memo. There were no limits saying they can only be used one at a time. There were no limits. The duration was not limited. They just said that. And so what you have is a situation where they didn't put the limits on, and then where the chances of them being used in combinations, which then amount to torture, is very, very high. So the fact that they didn't limit it, the fact that they didn't time on it, the fact that they didn't say one thing had to be used alone without another, and even then, as I said, some of those alone constitute, in my view, torture.
One quick point and two concessions. First, I think there's no evidence that waterboarding was ever used by anyone under the approval of Haynes or Rumsfeld. I'd bet a lot of money on that. Certainly not on Qahtani, because we have a very detailed record. But the two concessions are, I think they warrant severe criticism. I know Haynes, I like Haynes, but I've said he warrants severe criticism for failing to impose limits. The question is whether that was criminal. Now, the other concession is, if I were Eric Holder and I were the new Attorney General and you were to send me a memo, which you probably will, on why he should prosecute Rumsfeld and Haynes, yeah. When I say no, there shouldn't be an investigation or prosecution, I don't mean that quite as literally as it sounds. If I were Holder, I'd tell the head of the criminal division to take one of his best lawyers and look at all available facts on this, quietly, privately, without kind of hauling people into a grand jury initially, and make a judgment whether this looks like something that should be prosecuted. And if the judgment turns out to be yes, which I doubt, take that up the chain of command and see whether they think it's something that ought to be done. What I oppose,
not a bad suggestion.
What I oppose is a huge special prosecutor production, Lawrence Walsh style, Ken Starr style, or the Scooter Libby guy, because we have a long history that shows that because of the incentives of being appointed to one case, and unless you prosecute people in that one case, you ain't nothing. Special prosecutor type appointments tend to lead to incentives toward overzealousness.
You know, it's a thoughtful suggestion, Stuart. I think the problem with DOJ right now, and even under a new Attorney General, it has been corrupted pretty deeply. And whether it has the public acceptance, even with the new Attorney General, from the attorney scandal to the torture stuff, to the prosecutions going on, in Arkansas or Alabama. I just think the problem of someone with injustice actually doing this and going after people who may still be there or looking at people and getting public acceptance of it, I'm worried about. I'm not definitely. I'm saying your suggestion is not bad. It's staying. We're going to start an inquiry. We're going to start a criminal investigation of some sort. Not criminal, but at least an investigation to look at that is at least the start. I do think there's another element here, which is the public. And what do we do about that? And, you know, there's suggestions around that that you hear everywhere from a truth commission to a commission of inquiry, which is where Scott Horton comes down in this new Harper's article. And I would think that in addition to having a criminal-type inquiry of some sort at justice or with a special prosecutor, that you have to have some kind of commission of inquiry, because what happened here over 7 years has really damaged, I think, not just human beings, which it has in our clients, but damaged really the idea that the United States once stood for something, and that we could criticize other countries that were engaged in torture, and our State Department reports and were accepted, and that we could say to another country that was doing torture, stop it, we don't do it, or we could save our own soldiers by saying that. We can't do that anymore. And I don't think without having some way of engaging the public on this, that you can just do some kind of secret, quiet thing.
Before you respond, Stuart, I'd like to ask you also to answer this question, which is, how does your last statement about what Eric Holder ought to do, how can you reconcile that with your call to pardon most of the senior people? It seems to me that there is some tension between those positions, even though, as I know, you have called for some kind of truth and reconciliation type approach to getting to the bottom of what happened.
Yeah, there is some tension between them, and my suggestion that Bush should pardon them is to some extent, although I didn't couch it that way at the time, contingent on what the risk appears to be of an out-of-control investigation at the time when Bush has to decide whether to do that or not, and maybe depending on what the Obama administration to come says between now and the end of Bush's term, maybe I would say, well, he doesn't really need to do that. They seem like they've got it under control. I am concerned about, for example, congressional committees having endless inquiries, calling people in, subpoenaing them, setting perjury traps, finding little contradictions between what they say or things that are debatable, sending up perjury referrals. So it's not entirely, when that starts, it's kind of it gets out of control of the executive branch, at least if it's in the same party. Now, I have supported a commission of inquiry in the same article, not a criminal investigation, a commission of inquiry. Since I wrote it, I've talked to some Obama people and some of them think it's a bad idea just because they think we're going to be, that the tear up the country partisan warfare problem is going to be presented by that. And frankly, I have mixed feelings between those two considerations. One last point is Michael's point on the Justice Department being corrupted takes me back to 1992 and the famous Iraq-Gate scandal, which nobody remembers. But let me quickly reprise it. This is not Iran-Contra. It was the claim that the the first Bush had secretly and illegally armed Iraq and then had orchestrated, before the Gulf War, then orchestrated a criminal cover-up with the Justice Department to cover it up, involving something called the Banco Nazionale del Lavoro. Now, there were 2 60 Minutes has done this, about 11 nightlines, 2 covers of U.S. News and World Report, 100 front-page stories in the L.A. Times. This was huge. Al Gore, a month before the '92 election, talking about the corruption of the Justice Department under Bush, said this was a scandal worse than Watergate ever was. That was verbatim. I was thinking at the time and writing a letter, it kind of seems like a lot of bull to me. I wasn't sure then. Janet Reno comes in, finally, as Attorney General, and is stuck with Gore's allegations. So she assigns not some career guy who was corrupted by the Bush administration. She assigns her right-hand man from Miami, who came in as a political appointee, John Hogan, to investigate this and get to the bottom of it, and he does, and he works on it for about a year. And he finally, very quietly, maybe late on a Friday night, puts out a memo that says, "Nobody did anything wrong." Well, now, I'm not, people did things wrong here. But the Justice Department, under new, respected leadership for Eric Holder, I don't think they're going to have a problem.
Here's the problem. You actually alluded to the problem, which now I recall. You said that some people in the Congress were alerted to what was going on, Nancy Pelosi and others on the Intelligence Committee. And the question you have in a Justice Department, that's a Democratic Justice Department, is whether there's going to be an urge to protect people who had maybe not culpable in terms of the sense of actually authorizing the program, but who had knowledge. And so I worry a lot about not having someone independent.
I worry a lot about having someone independent, so maybe we can leave it there.
And this seems like a perfectly good time to invite questions from audience members. And anyone who has a question, please come to the microphone and just state your name, just so we know who you are. While that's happening, let me pose one question. I'd like to start with Michael. You really have three groups of defendants in your indictment in this book here. One are high-ranking policy makers, including Rumsfeld, Tenet, Steve Carbone. You have high-ranking military personnel, including General Sanchez and others who are in the chain of command, mostly in Iraq. And you have the lawyers, Alberto Gonzalez, William Haynes, David Addington, John Yoo. Quite a fairly large cast of lawyer defendants. Which group of defendants do you think you have the best case against, and why? You can only prosecute your case against one of these groups. Which do you think are most culpable?
One of these groups?
Yeah. You've got policymakers and you have military people.
Well, you know, the lawyers are always the interesting and debatable point, because even lawyers in my office who like to give advice, they like to say, well, we never want to go to jail for advice. But on the other hand, if I looked at the most culpable people here, it would be Addington, Yoo, and Gonzalez.
Let me interrupt you for 1 minute. Your book makes what I think is a fairly sensational analogy. That is, you compare the lawyers who were crafting these policies to the lawyers tried in the Nuremberg war crimes proceeding. And you cite the justice case, the famous justice case, which resulted in the famous Judgment in Nuremberg movie, which is a classic for those of you who have not seen it. And you cite the United States versus Allstatter case, which was the case against the Nazi lawyers who crafted some of their policies that were carried out, particularly the night and fog policies and so forth. So that's a fairly sensational claim, and I think it would be helpful if you could explain why you think that precedent actually is applicable here. And then, of course, I'd want Stuart to respond.
I mean, I think you have to be very careful, obviously, when you draw analogies between what's going on, what went on the last 7 years, and what happened in Nazi Germany. Unfortunately, there's parallels in terms of, not the number, but in terms of some of the types of conduct. So, for example, one of the lawyers who was killed eventually, Hans Litten, was put into protective custody, not taken to a court, and that, you know, there's analogies to that happening here. Now, the Altsetter case in particular, the legal principle that came out of that to lawyers here is that you can't give unwarranted legal advice where the foreseeable result of that advice will be the commission of crimes, or, you know, murder or whatever. And that's, at least, if you're thinking about the lawyers, one of the principles, one of the ways you have to think about lawyers, and whether Harold Coe called, you know, Yoo opinions the worst legal opinion he's ever written, he's ever seen, I mean, in his life, and completely unwarranted. So you have an unwarranted legal opinion with knowing what the consequences were going to be, which was to violate these two statutes, but for that opinion. And it has some analogy in my mind to like what you do in civil rights cases. It's like going against clearly established law. It's basically, there's clearly established law, but you're OLC, and you're going to write something that figures out a little hole in clearly established law, and it's going to have unwarranted consequences. So that's the way in which I think Altsetter is relevant. But as I said, I think with regard to the lawyers, there's also more than that. I mean, I think they were part of this group, cabal, whatever word you want to use, conspiracy, that got together and decided we want to interrogate people in a certain way. How are we going to get rid of the laws? And that's what they did.
I don't know very much about Nuremberg, so I won't tease that analogy too hard. I would just say two things. One, I think that what the lawyers were accused of there is probably a lot different than what the lawyers are accused of here. Second, I wouldn't necessarily assume that everything that was done at Nuremberg, victor's justice, as some called it, was impeccable. But looking more to the particulars of this case, I have a friend, an old friend, who was one of the lawyers involved here. I won't name the person, and who approves some of the techniques done here. And this person agonized a lot over what was done and disapproved a lot of what was done, and his basic complaint was, I kept telling the White House that they needed to set policy limits, that just because we say something is legal, which is an interpretation of a statute, doesn't mean we're saying you ought to do it. And they should not have done it in many cases, but the White House refused to put any policy limits beyond the limits of the law. And I think, maybe not all of the lawyers, but certainly some of the lawyers, a good defense on that basis. Second, it's easy to call people conspiracies when you have a group of people that you don't like what they do. I imagine CCR has probably been called a conspiracy from time to time.
Oh, it plainly is.
But looking at history, FDR, war criminal, firebombing of Dresden and Tokyo, into the war with a secret unconstitutional destroyer deal, wiretaps throughout the war approved in about a one-page memo by Robert Jackson, Truman, atom bombs, Kennedy, Bay of Pigs, Cuban missiles, assassination plots against Castro and Lumumba, LBJ, make your own list, Clinton, bombing Kosovo, bombing Bosnia without UN sanction, violation of international law under the UN Charter, shooting missiles at Osama bin Laden, trying to kill him, despite the assassination ban. Renditions, there were something like 90 renditions. People talk about them as though they were invented by the Bush administration. They were invented a long time ago, and about 90 of them were done by the Clinton administration. There's one story in Ben Wittes's new book about Lloyd Cutler. There was a rendition being proposed. Lloyd Cutler, my old friend, late great Washington lawyer, White House counsel, said, but it violates international law, and he had Clinton going. And then Gore comes in and says, he's a terrorist. Of course it violates international law. That's why it's a secret. Go grab his ass. So once we start prosecuting people for conspiracy under the kind of loose standards we're talking about, I'm not sure that any administration, including the coming Obama administration, could stand the test.
Okay. So I think, one answer to that, because I've thought about this, look, I know about the Phoenix program and what the CIA did in Vietnam. I mean, this is, pretty rough stuff. And of course, I think that program in particular probably should have resulted in a prosecution. But in this case, what I started off with, and what I think is that this is really almost the first time in my legal career that I've actually saw an assault on the prohibition of torture itself. That actual prohibition, there was an assault on it by government officials, and there was an assault on the idea that this country is under the rule of law. And when you read those memos, they basically say, in the name of national security, the president can take any action and do whatever he wants, which is your example, put 500 people on the beach and murder them. I think that is why I think this particular situation really merits it. What this administration went out there and did was assault the law, assault the prohibition, and do it publicly and notoriously. And they did it in a way in which, I remember when we won the Vladeck case, which is the ATS case, Judge Kaufman wrote the opinion, and he said, the argument was every country tortures. Why should we, Paraguay, be in trouble here because of this, or Vladeck or Peñarela be in trouble for this? And the judge said, the reason we have the prohibition on torture, what it means is when you get caught torturing, you basically say, we didn't do it, or you denied it. And that's what really changed in the last 7 years.
Certainly, there's been a long history of torture. There's an interesting long paper written by a recent college graduate named Will Levy's grandson of former Attorney General William Levy, who says actually United States Army practice throughout much of American history was a lot closer to what the Bush administration has done than one might think. But yes, this is the first situation in which I think the threat of catastrophic damage to the United States could plausibly be thought of as being stoppable only by extracting secrets from hardened people who don't want to tell you anything. And therefore, I think the temptation to push the line, again, not everything that's coercive is torture, and we can talk about that, but the temptation to push the line, to go up to the edge, has been stronger in this case. But would you rather be tortured to death by having a firebomb land on you with 100,000 other people in Tokyo at the end of World War II. I think I'd rather be waterboarded than that. So although we viscerally recoil from torture, I think that a whole lot more damage has been done to a whole lot more people, innocent people. These were not innocent people who were arguably tortured by the Bush administration, and there weren't very many of them compared to what was done in World War II, just for one example.
Well, let me ask a question to both of you. Listening to this debate, one might conclude that war crimes are really only for the vanquished. They're not for winners. Winners don't commit war crimes, no matter how atrocious their conduct might be. What's wrong with that statement?
Well, I think it's certainly there's going to be resistance among the winners to prosecuting their own people for war crimes, much more than prosecuting the enemy for war crimes. That's just human nature. I certainly don't think that war crimes by the victors should never be punished, and I hope that doesn't seem to be what I'm arguing here. I think that it should that closely held facts to decide whether A, what you have is a war crime, B, whether matter of prosecutorial discretion is prosecutable. Now, there are some people who clearly should be. There are some people who are at Abu Ghraib and elsewhere in Afghanistan who are just sadistically torturing people without authority from on high. Some of them have been prosecuted, and probably more of them should be prosecuted. But I think you should think twice before you decide that not just Bush, not just Cheney, not just Rumsfeld, not just even Condoleezza Rice, but Colin Powell, George Tenet, the entire echelon, top echelon of the administration and all their lawyers, we now know from news reports, knew of and approved waterboarding and other techniques. If they're all war criminals, I find that concept a little hard. You know, I find it a little hard to think of them in the same category as Hitler's people.
You know, that's the saddest part, really, to me when I read through a lot of these papers, is the idea. In some way, it was so mechanistic and so bureaucratic that these guys sat around the table in the principals committee, and they decided, you know, how they should be waterboarding people and approving that. And Ashcroft is saying to them, we shouldn't be discussing this in the White House. Anything that really calls forth a need for a criminal investigation, it's that it got to that level. And it got to that level despite there being a tremendous amount of dissent within the government. People like Taguba, who I read afterwards, of course, Alberto Mora, who was the Navy defense lawyer, who went to Haynes, tried to get him to stop it, and who actually resigned and now actually thinks that war crimes were committed. The entire FBI, CIA people who refused to actually engage in so-called enhanced interrogation techniques. So it's not like they didn't know. But the fact that it got up to this level of people sitting around, really, to me, all the more reason calls for a criminal investigation.
Well, it certainly is ugly. But, for example, we know that Colin Powell approved waterboarding. Should he be prosecuted as a war criminal?
My view of someone who approves waterboarding, they should certainly be investigated, criminally investigated, and then prosecuted if it shows that what you're saying is true. I have no issue about it. I would do him for the Iraq War, though, so I'd get him on something else. But yeah, I don't have any. That's you know, I think that if it's true that he approved waterboarding.
Well, it's been publicly reported and it hasn't been denied, which is usually people who are accused of war crimes that didn't happen deny them.
I mean, one of the things people don't think about also in these, you know, is the question of what, you know, is what they were really after here. Here they know from a lot of their own intelligence, from the Army, and the CIA wasn't really involved much in interrogation, but from Army and FBI people, the best way to interrogate people. And then they go off and they do this, and then as you start reading, particularly in the beginning, you know, there's a certain element of vengeance in it and of not of really getting at information. And I just wonder to what extent we're putting up this whole thing, this national emergency and all this, but whether it's really much more about vengeance.
So I doubt it. Self-serving, perhaps, but George Tenet has said that what he would call enhanced interrogation techniques and you would call torture, brought us more life-saving information than everything else the government was doing combined.
Jane tears him apart with Abu Zubaydah, just tears him apart. You know, he's one of the, I mean, there were 100 people in secret CIA sites, at least, I don't know how many, they claimed 33 were waterboarded, I think it's probably a lot higher, but what was going on in those secret sites is really unspeakable. And if there's someone at the top of this who was a guy who knew and approved, and I think those were approved all the way up through Bush, those are really bad.
I've read the book. I'm not convinced that by the arguments that all this was for naught.
Can we take a question from the audience?
Yeah.
There's one.
My name is Ali Garib, and I'm a reporter with Interpress Service, and I just want to correct the record on Hitchens, who he did say that in the period of, I think it was a couple of months between when he was tortured and when he wrote the article, that he had suffered from nightmares, claustrophobia, and also a shortness of breath. And I was wondering if you would consider that prolonged mental harm. And also on the issue of the 5 o'clock to 6 o'clock question, if we're going to stand on principles and say, would you, in the hypothetical of would you stop somebody from torturing somebody to save your son? I mean, I raised my son on principles and morals, and I certainly wouldn't want to attend my child's funeral, but I would have trouble looking them in the eye and telling them that I had approved torture as well. If you could comment on that, thank you.
Yeah, on the first point, you would stop to the police if it were your child. Pardon? Yeah. Well, I respect that view. I respectfully disagree with it. On Hitchens, I would have to reread his article. I didn't, immediately recall what he said about after effects, and you can make a case, depending on how long they went and so forth, that it was prolonged mental harm. I think the passage I read you, which is in his article, suggests that kind of undercuts the idea that this was really the worst kind of torture. And
physical effect, though, right?
well, I mean, he was ready to have another go. He likened it to foreplay. So how long is prolonged? How much did Hitchens suffer afterwards? And certainly Hitchens, especially on the mental front, had a reason. He knew that they wouldn't stop when he said stop, and so I don't claim that his position is entirely comparable. But I do think that the passage I read, coming from a person who said I think this is torture, tends to make you hesitate and say, well, not so sure.
Question?
Yeah, hello. My name is Jan Kratochwil. I just have a question. We've heard a few policy arguments why we shouldn't prosecute. But I was wondering whether the law also doesn't have something to say about it. I'm now obviously thinking about international law, because actually, as a matter of international law, the U.S. is obliged to prosecute torture. It's included in the Convention Against Torture and many other treaties. So I was just wondering whether that the picture or the argument we are talking about.
International law, as I opened with, in international law, they have no defenses under international law. They're finished. I mean, the memos don't have any applicability. A pardon doesn't have any applicability. You can't pardon war crimes and torture. They can't put up anything. They have no shield, really. And international law does, of course, through the Convention Against Torture, require either prosecution or extradition, investigation or extradition. Who is here and who is alleged to be a torturer. So yes, the U.S. would be breaching its international obligations not to at least begin an investigation of people who may well have been involved in torture.
I think not. I'm not an expert. I believe has never conceded that international law can oblige the United States to prosecute or extradite someone who did not violate U.S. law. And I think it never should. I think in particular that in cases like this, international law is often more political than domestic law on such matters, and that it tends to be a lot, there are a lot of European judges. I'll give you an example. Balthazar Garzón, the hero of the Pinochet extradition, was quoted saying soon after 9/11 that he would like to prosecute George W. Bush if he could get his hands on him. For what? For talking about, not having yet started, bombing Afghanistan in order to strike back after 9/11. Balthazar Garzón apparently thinks that our Afghan war was itself a crime. I don't want my laws being written by people like that.
Let me go back on this for a second, because this is about the Convention Against Torture. And what it says is a torturer is here, you have to investigate or extradite. And yes, the Convention's definition of torture is broader than our own. But even if there's suspicion that under our own laws there was torture, which I certainly, whether you agree with my view or not, there's at least suspicion that there was torture here by high-level U.S. officials, then there's an obligation under our own laws to say, well, our own laws may have been violated, and therefore we have to begin an investigation. It's not really applying international law. This is a ratified treaty of the United States, the Convention Against Torture.
Well, you need an investigation if there's reason to believe that there are non-public facts that would create a crime where it isn't just sitting there in front of you.
I think that's right.
And that's what I meant when I said if I were colder, I would have people look into some things.
There's one last question.
Gabriel Weil, I'm on 1L here. Mr. Taylor alluded to this, but I'm curious how you would respond to the comparison with collateral damage, which is basically an automatic part of modern warfare, and innocent people are dying, and how you can have a consistent system that outlaws torture without outlawing anything that produces collateral damage.
Well, of course, collateral damage, if it's carried out contrary to the Geneva Conventions, is a war crime. I mean, you just never get it prosecuted except by the victors if it's done.
So, are you advocating
if it's not proportional? It's a war. If you want to drop an atom bomb to kill one person and you kill 100,000 people, that's not a proportional use of force, and it would be considered a war crime. Likewise, so that collateral damage is a term that could encompass both a war crime and not a war crime. The problem with war crimes, the problem with those kind of war crimes that have the use of force, is they're probably the hardest thing to get at. In my 40-year legal career, I would say that whether it's an illegal use of force or a legal use of force, or it's proportional or not proportional, or whether it's targeting or not targeting, is probably the hardest thing to get to. And we're not really close to it, except with probably some kind of victor's justice. And even then, you're not that close to it because they don't want that precedent back on themselves. So I would say it's essentially not very enforceable.
Quick point on that. I think it's a very good question, and I think it calls to mind there's a distinction between collateral damage and just terrorizing people by killing civilians for that purpose. And there's also, I think, there's a case to be made historically that Hiroshima was a target that involved a lot of collateral damage. The case is much harder to make as to Dresden and Tokyo, the fire bombings of which they were not very substantial military targets. There's a case to be made that what FDR and Truman and Churchill were doing there was trying to bring the war to an end sooner by burning to death a lot of innocent civilians in Japan and Germany. And I think, frankly, it's very hard to back on that time and come to a confident judgment on them.
If you go to the War Museum in London, where Churchill has the papers from Dresden, he has them on the wall, and there's a letter he writes that said, "I think we may have committed war crimes in Dresden." Yeah, they may have, and they may have been justifiable war crimes if they saved more lives than they cost. So then it's not a war crime.
Well, I would make the distinction that the tough interrogation techniques here that were authorized from on high were done to about 30 people. 3 were waterboarded. We have no reason to think more than 3. And there was pretty good reason to think that all of them were complicit in 9/11. I'd say that as a matter of proportion and prosecutorial discretion, that's not in the same ballpark as burning to death a lot of innocent civilians.
Well, I think the numbers are a lot higher, but it's still not going to be in proportion, but it still is the same reason I said that I think you just can't allow administration to continue.
We have a question from this
My name is Charlotte Freeman. I have just 2 quick points. First of all, Mr. Ratner opened, in his introduction, he addressed his desire for the Obama administration to declassify documents, so we do have more information on what happened with the Bush administration in regards to torture. One of my main problems with your argument, Mr. Taylor, is that I feel that your argument is primarily based on doubts of evidence existing, but until we know if that evidence exists, I don't feel that your argument is valid. I don't think that we can circumvent justice based on opinions and doubts. And so I feel like the first step before prosecution would obviously be investigation, and that part of that investigation would be to declassify those documents. And especially because you're not taking a neutral standpoint here. If you were simply not commenting on the situation, it would be different. Not taking action, for example, like Mr. Ratner here. But instead, you're actually you're out actively disagreeing with the idea of prosecuting these officials. And I don't feel like you can take a definite stance based on a lack of evidence that we don't have access to. The second point was. Basically discussing when you discussed juries and made the comment on juries making mistakes. I just wanted to point out that frequently I think that's disregarding the issue of economic ability of defendants to provide themselves with adequate representation. I think that blaming mistakes in court on juries is certainly ignoring one of the huge problems in our judicial system, and that I just wonder if you therefore are saying that that juries should be eliminated from all criminal courts because they make mistakes, and in this case you were really referring not just juries but trials as well. So I'm curious if that was something you had been considering when you made that comment.
Well, a couple of points. One, I think the memos should be made public. That's not really investigation. They can just make them public if they want to. There may be some aspects of them that need to be classified, but by and large they should be made public. As to the rest of your point, I think that you've lost sight of in some ways, the cornerstone of fairness in the criminal justice system, which is called prosecutorial discretion. As Robert Jackson, maybe our greatest attorney general, said a long time ago, there's a gazillion crimes, I'm paraphrasing, crimes out there, and almost anybody could be prosecuted for something, and the most dangerous power is the prosecutor who picks somebody to try and pin a crime on, rather than looking at crimes that come on and that are brought to his attention and investigating those that most need to be prosecuted. Lavrenti Beria, I think Stalin's Secret Service director, put it this way: show me the man, I'll show you the crime. Now, that doesn't mean you should never investigate, but it does mean, I think, unless you have something, unless what's on the public record gives you some reason to suspect, not just to imagine that in some conceivable world, some reason to suspect that uncovering further facts would show there's a crime, or that there's a crime already, which you can prove better by uncovering further facts. I don't think it's the business of prosecutors, especially prosecutors in a change of administrations, to go looking around, turning over every rock in what the previous administration did for evidence of crimes. As to juries and trials, I don't trust juries. I don't trust trials. They're the last point barrier to somebody being unfairly sent to jail. But that doesn't mean they're a good barrier. Prosecutorial discretion wouldn't have to exist if juries, or at least would play a less much important role. There are two major reasons for prosecutorial discretion. One is there's a lot more possible crimes and possible investigations than any prosecutor can do. So you've got to settle on the most important stuff. The second is precisely an implicit distrust of the jury system and knowledge that you can convict innocent people in part because of flaws in the juries, in part because of flaws in the process, and it's happened lots of times. I'm not saying get rid of the jury system. I don't know of a better way to try criminal cases, but I'm saying that we ought to have better protections, not worse protections, against prosecutors just going to a jury. Let's take the grand jury yesterday. Did you read about the grand jury in Texas that indicted?
I didn't want to start off with a joke here.
He indicted his political rivals He indicted Cheney and he indicted Gonzalez, but he didn't indict him for torture.
No, I know.
What did he indict him for?
Yeah, at first, I was really excited. He indicted him for owning part of a company that owns a prison in which there was an assault or something.
Yeah, I mean, you might as well indict him because somebody in San Francisco chewed gum the wrong way.
But let's go back.
That's a grand jury for you. Now,
public knowledge, because I think what you have here is a vast amount of public knowledge that would really indicate a serious criminal investigation. I mean, I think you practically said that some kind of investigation should happen. I mean, I have books at home. They're just called the torture papers. You've seen them. They're 1,000 pages long, in which they go through the memos, they go through Rumsfeld, Haynes's authorization for the techniques. You have books that document what happened in the secret sites. You have books that document what happened in Iraq when the so-called Rumsfeld techniques went over to Iraq. It's just out there.
I agree.
It's public. Now, whether you and I disagree about whether it gets up to the point of is it a crime yet or is it a crime if you go farther, but it certainly indicates that you need a serious criminal investigation.
A more subtle disagreement. I think that cuts both ways. There is a vast amount of information, and you've written your book and your indictments based on some of that information. But I think what the Justice Department needs to think about is, first, what are the standards? What would make it a crime? Is it a crime on its face based on what that we know? I think no. And then the question is, well, if we investigate, what kind of additional information might lead us to the conclusion, oh my God, Rumsfeld did commit a crime, and is there any reasonable prospect that a big investigation would uncover such information? Littler investigations I have less problem with. Well, we better check on this, we better check on that. This one bothers us, let's dig into this a little deeper. But appointing Ken Starr to look at the whole business, or somebody like him, I like Ken Starr, but I think he got a little carried away.
Compared to what we've had special prosecutors for?
Well, we shouldn't have.
This is, of all the cases where there should be one, I mean, compared to the combination of whitewater and sex, I mean, come on.
I'll agree with your conclusion, but dispute your premise, which is that we should have had those special prosecutors. I think special prosecutors have proved to be a disaster as an institution, and we should not have any more.
Thank you. I'm Sarah Greenberg with Physicians for Human Rights. I want to push back on the assertion that because waterboarding is part of training of our soldiers, that somehow it does not cause prolonged mental harm. To equate that with the scenario of waterboarding detainees in custody is just ridiculous. Waterboarding, when used in training our own soldiers, is used to prepare them in case they are ever captured and tortured by our enemies. It was never intended to be reverse engineered and used in an interrogation setting. And when it is used in training, those that are engaging in the waterboarding and those who are subjected to it are closely monitored by medical professionals, and they undergo psychological evaluations both before and after. And I just don't understand what comfort you get, Mr. Taylor, in cuddling up to waterboarding.
Well, yes, it's different. Yes, it's not the same when we do it to our own soldiers, in particular because they know that it's only going to be carried so far. But the idea that the comparison is ridiculous, I don't accept. I think the question is, in part because we don't know. It has never become public what limitations were put on it. You talk about monitored by medical professionals. Maybe it was monitored by medical professionals.
Why get close to the line?
Pardon?
Why even get close to the line?
Of torture?
Of waterboarding. Why allow it at all? As Mr. Ratner said earlier, why draw a box around what...
I would not allow it. The question we're debating here is whether the people who did allow it should be criminally prosecuted. And I see a lot of space between what I think is a good idea for people to do, or a bad idea, and what I think should be criminally prosecuted. And I think waterboarding lies in that space. It's a terrible idea. The Obama administration should pass a new statute that makes it clear that waterboarding is illegal then from here forward, whatever it was in the past. But the issue here is whether we should be prosecuting people who have done it.
I do think that's an indication to me, Stuart, of how serious the problem we have here. That if you can really say that you think it's a policy matter as to whether we waterboard people in a certain way, then my view is an insistence, really, that we have a criminal investigation of it is more strenuous, because you're a respectable New York Times journalist with a lot of a popular audience out there. And the idea that we could sit here and say, well, it's a policy matter about waterboarding is really shocking to me.
Stuart, you get the last word.
Well, I don't think I quite said that. I think waterboarding is deplorable. The question is whether it was a clear policy so clearly illegal that people should be prosecuted by the same Justice Department that advised them it was legal. That's my point. Now, looking forward, frankly, let's broaden the picture here. I think there are a lot of prosecutions that shouldn't be done that are done in this country. We've got 2 million people in prison. That's about 1 million and plus too many, in my opinion. People are sent for long prison terms for having a little... I think we overuse the criminal sanction in this country, and we overestimate what benefits we get from it. And I think that applies in this context as well. You could easily draft a statute, and presumably John Yoo is not going to be appointed to the Office of Legal Counsel again. You could easily draft a statute going forward that would outlaw whatever it is you want to outlaw, as opposed to prosecuting people based on this extremely narrow, extremely vague, extremely debatable statute that we now have on the books.
I would like to ask the audience to join me in thanking both Stuart Taylor and Michael Ratner.
Thank you, David. Thank you, Stuart.
It exemplifies the best spirit of the law school, where you can have a vigorous spirited debate, and then we can all go get a beer afterwards.
If I had time, I would.
I was hoping there might be a beer.
Thank you, David. Thanks, Stuart. It was fun.
Appreciate it. If I'm not stoned, you did that first. Pardon?